So I have 7 questions I'm going to try to get in quickly, and if there's a yes or a no, I would appreciate it, but please take the prerogatives of a witness and expand. But I want to go back to the question about the incident that occurred at Pioneer Courthouse Square, because both Commissioner Leonard and Commissioner Salrzman have alluded to this. And I appreciate that, your position that you embrace the compromise that was worked out in 2005, but you still have some constitutional concerns about it. But let's take the incident that happened, the specific facts. Chief Reese was brought in at a particular time and was tasked with helping with some of the operational stuff that occurred with the FBI. But he did sign a confidentiality agreement under which he was not able to notify the mayor or any city commissioner that he was involved in this. So just to clarify, I take it you view that as unacceptable, and I take it you further view that as a violation of the 2005 agreement?
Yes.
Okay. So in terms of Andrea, the issues that you framed at the beginning in your testimony about the concerns of both oversight and state law, what occurred in this case that gives you any comfort that either of those concerns you've raised were addressed in a responsible fashion by the City of Portland?
Well, I'm not sure I completely understand your question. In terms of the concerns we've raised, I think those concerns cannot be fully addressed with the resolution. It is the trust issue related to that incident. But we do know that it, as you just asked, we don't think it was followed. But maybe if you can clarify your question. Because
well, I have confidence in Chief Mike Reese. Now, I also I'm supposed to play a civilian oversight role, but if you tell me that Chief Reese signed a confidentiality agreement and participated in the end game of that investigation, I begin with a high degree of trust and confidence in his judgment. But you began your testimony by saying that the 2 major concerns you had to do with potential violations of state law and oversight. And my question is, what gives you any confidence that either of those 2 concerns were addressed in the ad hoc cooperation that occurred between the FBI and the Police Bureau in connection with the incident at Pioneer Courthouse Square?
Well, I don't think we know the answers to those questions, and I doubt we're going to get the answers to those questions completely today. We have an ongoing criminal case, which is going to restrict both what the U.S. Attorney and the Special Agent in charge of the FBI can say about it until that case comes to trial or is otherwise resolved. Not to mention issues related to who had access to classified information and who didn't. I expect that they will talk about the need to know. I remember reading Mayor Adams' speculation about why he wasn't informed, which was that it wasn't a real threat. It was a threat that was completely orchestrated and controlled by the FBI very carefully, and thankfully it was. So I don't think we're going to get all of the answers to that. We certainly...
Let me cut you off, because I appreciate that, and what I'm just trying to signal is, as I'm listening carefully to your position and trying to understand the difference between full participation in the JTTF and the ad hoc system we've created, I'm trying to make sure I understand how the constitutional legal concerns that you've addressed are handled differently under an ad hoc system versus full participation. And I realize there's some gray.
Under the ad hoc system, Portland officers, to the extent they're creating investigatory records, those are going to be Portland records, not FBI records, subject to the oversight of the city attorney and the auditor for review, the auditor's office for review. And so there is at least the likelihood and the possibility, we would hope, of the oversight system working properly as long as the cooperation is case by case. If it's direct participation, there's no chance of having that oversight.
So let me pursue that for a second, because I've been thinking about the issue that you've raised and been very eloquent on, which is whether or not the city attorney needs to be in the loop here, whether the city attorney needs to have a role. And I want to just get your reaction to a thought. Well, the city attorney, and we have a wonderful city attorney, and I don't know that she has any particular background in criminal law, but I have great confidence in her as a lawyer, and she certainly can review files and follow the guidelines. But is she the best, and is that person the best suited person to perform the function that you're recommending, or is it more appropriate for the chief law enforcement officer of the state of Oregon, charged with enforcing state law, that would be Attorney General John Kroger, to be in the position of reviewing files on some kind of basis?
If the city wants to pay the State Department of Justice to audit its files, I'm sure they would be happy to.
Well, would you have more confidence in a system where where the Attorney General for the state of Oregon, who is our chief law enforcement officer, has a role in ensuring compliance with state law, versus the city attorney, who may very well be a civil lawyer, who has maybe less experience with criminal matters?
The concern I have is you're removing it out of the city sort of chain of command, the authority to the city attorney to report to you and to the mayor. Not all city attorneys in that office. There is one who's worked on this particular issue who has a criminal background, who I think is maybe the one even tasked with reviewing the files right now. So I think we have the tools here. And while I wouldn't mind having a subsequent audit or an additional audit, indeed by all agencies, by the Attorney General, I do not think Portland should delegate or remove its authority and its duty to ensure review. And let's not forget, it's also seeking the legal advice at the front end. It's a dynamic, ongoing role to which the officers and the chain of command can seek the advice so that they don't do what we all thought they weren't doing in the 70s and the 80s and the 90s, and potentially more recently, we just don't know.
So let me ask Mr. German a question, because you've traveled a long way, and you give us the benefit of a national perspective on this. My crack team pulled up Indiana Code 5-2-4-1, which looks strikingly similar to the state law that we've been talking about that puts limitations on the collection of certain information. Do you have any experience with how the Indiana's experience under JTTF, and whether they've been able to balance their state law prohibition with participation in the JTTF?
No, I don't have any on particularly the Joint Terrorism Task Force. There were a number of states that started looking at their laws on criminal intelligence collection around the time that fusion centers, which are sort of a separate intelligence collection operation, opportunity, structure, facility, whatever you want to call it, but was going to be under the auspices of the state rather than the auspices of the FBI, even though the FBI is involved with Department of Homeland Security and a number of other federal agencies, including resources funding. So I know that there was a lot of concern when those were being stood up about whether the state and local laws were going to be enough to counteract what the federal government was suggesting.
So if you have, subsequent to this hearing, if you had some information on that, because the Indiana statute is similar, I'd just be interested. I have 1 minute left. Let me get two others quickly. You referenced the OIG rule on has or may be involved in criminal conduct. The Oregon statute is or may be involved in criminal conduct. I don't want to get too much into the lawyering here, but it'd be helpful for us to have a sort of your common sense interpretation of what's the difference between page 21 of the guidelines, which you state creates this loophole, this opportunity to infringe constitutional rights, and the language of state law, which refers to someone who is or may be involved in criminal conduct, because I didn't catch the distinction.
The distinction is reasonable suspicion. which has been described as a reasonable factual basis that would give a prudent law enforcement officer suspicion that this is happening, as opposed to the mere possibility that something could happen.
So that's the piece. So that's
Right.
it's the reasonable grounds to suspect
Right.
clause of state law that
Right.
you believe is not in the federal guidelines.
And the Attorney General guidelines are clear that no factual basis is required to create that.
And I would add the reasonable grounds in Oregon law have to be connected to the subject of the information that is or may be involved in criminal conduct. So it's very narrowed down to the subject. They have to have the tie to an actual person, and that's the information you collect. Not on Cop Watch and Dan Hamlin and peaceful protest where it's non-criminal information.